So Peter, I believe there was a little bit of fun and games at the TPN offices yesterday.
Lots of excitement for our IT team yesterday. I think they're trying to steal a little bit of our thunder.
I believe there's some video footage of them, and Piet and Michelle, who are producing our videos, our content, gave them a little bit of an opportunity to shine.
Correct, Michelle, and we're going to show those videos today.
Not now.
Very
not
exciting.
Now. A little bit later on. So folks, you're going to have to wait and see how the IT team gets involved in the distraction of data, because that's what today's session is around.
Correct, Michelle. In the first 3 sessions, we actually went through the TPN POPI-Portal and went through some of the different functions on the system itself. But today, something more practical.
We're going to have some fun. So we've got 10 modules on the training on this webinar series in terms of POPI and getting yourself ready for POPI, getting yourself compliant. Video 1, 2, and 3 is in YouTube in our playlist. So please do go back and watch those if you need to catch up. Retention of data, destruction of data, policies and procedures, they're different.
Definitely. It's not just about the legislation, it's the practical implementation of your policy and procedure.
So what you and Abel have done is you've created a table, and in that table you've said all the different types of data that may be in your organization. And for each of those, you've identified the retention period that you may hold on to that information for before you are required in law to start destroying it.
Correct, and that policy and procedure also sets out the practical methodology about the destruction as well.
Okay, so and our clients can go and find that in the POPI-Portal, in the policy section, in the menu option on the left-hand side, under the policy for retention and destruction of
100%
data.
correct, myself.
Perfect.
Yes.
But you're going to take us through that now. So you've got the policy, and that speaks to how long we can retain data for, but actually it's about the implementation. Right?
Correct. At the end of the day, you can have the best policies in the whole entire world, but if you're not implementing those policies.
Right, so it's about the procedures, and that's what we've done some video footage on a little bit later, and we're going to take you through the practical process of how you destroy data. The implementation of that, for example, we've got a clear desk policy in TPN.
Correct.
Can't leave data lying around on a messy desk. And so if you have finished with a document and it's either in a locked stored environment or it is then put in a locked box in the office.
Yes.
And once a month, so the frequency for us is once a month, we have a supplier who then comes, unlocks that locked stored box, takes the contents out, and is escorted out the office with a TPN employee.
Correct.
Down into their truck, where it is physically shredded on site and gets signed off by a TPN employee.
And thus the control stays with us regarding the shredding, and we sign off on all of that as well.
Right. And then, of course, we've got the destruction of hardware.
And I thought it's as simple as deleting things.
Apparently you cannot delete stuff off a computer. So there's a little bit of destruction that goes on there, legitimately and literally. Okay, I'm going to hand over to you just in a moment, Peter. For our viewers today, just a few housekeeping rules for you to remember. The agenda is this session is an hour long. We're going to save the last 15 minutes to go through the Q&A. Please do log into your YouTube channel, because once you're logged in, the chat on the right-hand side, that'll allow you to enter your questions. My job here today is, as always, to facilitate those questions.
I think an important point as well, we dressed up for today's session. So if you don't see us properly and we're blurry, go and have a look at the cog at the bottom of your screen and go and set your settings to 720p or higher.
Exactly.
Because then you'll be able to see us.
Right, so if we are blurry, that little cog, click on quality, and then you can change it to at least auto or 720p, and then Peter will look very dapper. You can compliment me back.
Michelle, yes. Very pretty as well.
Thank you. Okay, and then I'm going to be facilitating the Q&A, and of course we've got the feedback forms right at the end. So at the last 15 minutes, I'll post a link which you can then use to click on and give us our feedback. Very useful for us to make amendments and changes in terms of the content, the webinars, our speakers. So do please, and of course you get your CPD certificates at the end of it. So please do fill those in the last 15 minutes. Peter, I'm going to hand it over to you, and you're going to take us through retention and destruction.
Thank you very much, Michelle. Let's get going on this. So once again, morning everybody. Glad to have you all here. What we're going to cover in today's session specifically, something not too exciting. In the beginning, we're going to deal with the legislation, but it's vitally important that you start to understand exactly how the POPI Act specifically works and the interpretation thereof specifically when it comes to retention and destruction. So we're going to talk about the retention periods and life cycles of data. Then we're actually going to go and move into our own TPN retention policy and procedure, and then moving into shredding and best practices, as well as electronic data. And like Michelle said, never just delete things. It doesn't work that way. Apparently, you need to go through an entire process, which we're going to share with you today and give you some practical solutions to that specific electronic data deletion and destruction. And then, like Michelle said, we're going to go through the Q&A right at the end. Remember to log into YouTube to be able to access the chat, and please like and subscribe the page as well. So, data protection legislation, it's not just South African relevant. Like we've discussed, we've got all these things regarding GDPR and European citizens that filters through to the POPI Act as well. You can go and have a look at that in the first 3 sessions that we did. We did explain that to you as well. But it's very globally relevant because personal information is not just South African information. It's all across the world. So let's just get started with this. Having a look specifically at the legislation and sections of the legislation is vitally important when you're dealing with retention and restriction of records, as they call it in terms of Section 14 of POPI. So I'm going to read this for you, and then I'm going to give you a little bit of explanation depending on the subclauses if they don't necessarily make sense. So let's have a look at this. 14.1. Subject to Sections 2 and 3, records of personal information must not be retained any longer than is necessary for achieving the purposes for which the information was collected or subsequently processed. So we've already started talking a little bit about here is the 8 pillars of lawful processing in terms of POPI. And what we see here is retained any longer than is necessary to retain those records. We don't have time periods here in here whatsoever. Even if you have a look at subsection A, it says that the retention of the record is required or authorized by law. So you can keep that record as long as possible, that is necessary, if it is prescribed or authorized by other pieces of legislation. And that's why we've created this table for you, because it deals with multiple different pieces of legislation and how long you can actually keep the documentation, data, and information for. The responsible party must reasonably require the record for lawful purposes related to its functions or activities. So that's quite self-explanatory when you're dealing with this. It's the responsible party reasonably requires the information for lawful purposes of processing that information. Then C, the retention of the record is required by a contract between the parties thereto. Much like your lease agreements, much like your mandates, you need to keep the information of your tenants, of your clients, your landlords, for a certain period of time, depending on that piece of legislation that's obviously applicable, which we're going to deal through in that table section. The data subject to a competent person, where the data subject is a child, has consented to the retention of that record. That means that a data subject can consent to the information, the data, being kept longer than is necessary in terms of POPI specifically. And remember, when you're dealing with a child, specifically the guardian or the person in charge of that person needs to give consent as well. So it's not just the person in that regard. Dealing with subsection 2, records of personal information may be retained for periods in excess of those contemplated in subsection 1 for historical, statistical, or research purposes if the responsible party has established appropriate safeguards against the records being used for any other purposes. What are these safeguards that we're talking about? I'm going to give you a little bit of a definition on de-identifying personal information, de-identifying data, but that's one of the safeguards that could be put in place, is actually de-identifying the information so that you can't relate the specific data to an actual person with their ID number or with their name, addresses, etc. Then having a look at subsection 3, a responsible party that has used the record of personal information of a data subject to make a decision about that data subject must. And this obviously relates to your credit checks. This relates directly to that. You've used certain information to make a decision about the data subject. So it must retain the record for such period as may be required or prescribed by law or a code of conduct. Once again, the law plays a big factor over here, dealing with different parts of FIC, dealing with different parts of the applicable legislation when it comes to the retention of the records. If there is no law or code of conduct prescribing a retention period, retain the record for a period which will afford the data subject a reasonable opportunity, taking all considerations relating to the use of the personal information into account to request access to the record. So a person can obviously, in terms of POPI, as well as your PIA manuals, request that information be provided on them should you keep that information. So it's vitally important that that information be kept for a certain period so that the person can request that information that you have kept on them. Dealing with subsection 4 and subsection 5, a responsible party must destroy or delete a record of personal information or de-identify, once again that word de-identify, it as soon as reasonably practicable after the responsible party is no longer authorized to retain the record in terms of subsection 1 or 2. So here we've got different words that we're using now. We are talking about deletion of records, we are talking about destroying records, and we're talking about de-identify. Interestingly enough, there's no definition for destroy or deletion in terms of POPI, but there is for de-identify, which we're going to go through in the slides. The destruction or deletion of a record of personal information in terms of the subsection must be done in a manner that prevents its reconstruction in an intelligible form. And this, hopefully our IT team is going to show you today exactly how you destroy that data so that it cannot be reconstructed in any intelligible form. So dealing with the definition specifically when it comes to de-identify, excuse me, is very important because it speaks to how you can take information and not make it applicable or identifiable to a specific data subject, whether that be a natural person or a juristic person. And what we're dealing with here is the definition that says, in relation to a personal information of a data subject means to delete any information that identifies the data subject, so possibly a person's ID number, their address details, etc., can be used or manipulated by a reasonable, foreseeable method to identify the data subject. So once again, talking about that reconstruction of the data so that you can identify that person later. That's why it's so important, the proper destruction of the data itself, and can be linked by a reasonably foreseeable method to other information that identifies the data subject. So all quite self-explanatory, but when you're dealing with this definition, quite simple to remember. De-identify specifically means that you cannot relate that information that you're keeping to that specific person, data subject, natural person, or juristic entity. And like I said, destruction and deletion is not defined. And that's what we're going to deal with today when you deal with the shredding as well as the physical destruction of data elements and the processes that we at TPN actually don't use. So what does your policy state when it comes to how long the data, the information can be kept on your specific systems, whether that be internal servers, whether it be hard drives, whether it be on your laptop, whether it be physical information? You'll notice that all of these relate to electronic as well as physical information. So we're talking about the deletion and the destruction of records, not just in a physical method like shredding, but also in electronic methods that we're going to show you later. And obviously dealing with this table, and this table, like Michelle said, is part and parcel to your retention and destruction policy and procedure that is available to you directly off the TPN POPI-Portal. So once you log in, you'll notice you're going to fill out all your functions on the system, and on the left-hand side, it's going to have all your little subcategories, and one of those categories is policies. And all your policy documents are going to show up over there. All those procedures that you need to put in place for your business specifically to make you POPI compliant. Michelle actually mentioned in the introduction a clear screen, clear desk policy. That's one of the policies that's available on that policy page, but it relates to information that's actually kept on a person's desk as well as kept on their computer that might be accessible to another person accessing that or walking into the office.
Actually, Peter,
we've got a question, Michelle.
Yeah, can I interrupt you?
I need a sip of water, so go.
As I said, we have a clear desk policy, but the clear screen policy, in actual fact, your computer shuts down after 5 minutes.
Yes.
So if it is inactive and you're busy doing something else at your desk, it does actually shut down and lock you out.
Correct. And it's supposed to do that because at the end of the day, an unlocked computer is unlocked data. So you definitely should not allow that. And you should make sure with your, specifically your electronic access controls, that is in place. So with your company secretarial records, I'm quickly going to run through these. Obviously, all of you want information on your clients. How long can you keep the information of your clients? But these are also very, very relevant when it comes to your own business. And what we've got is specifically taken from the Companies Act, the Closed Corporations Act, and the acts dealing with juristic entities and specifically the company secretarial records that you need to deal with. So your notice of incorporation, they can be electronic and obviously physical. It's indefinite, you need to keep that information. Memorandums of incorporation and alterations or amendments, once again, indefinite. Rules, indefinite. Register of company secretary and auditors, indefinite. It's important information that you keep on the company, and of course you need that information specifically because it is dictated to you in terms of the Companies Act, the Closed Corporations Act. Yes, Michelle?
Peter, Jackie's got a question.
Yes.
She says, when you are no longer the managing agent of a property and the owner, after ending a period, asking for the information of the tenant, must we supply or must the tenant provide it to the owner, new agent or attorney?
So remember, at this point in time, the full POPI is not yet effective. It's only going to be from the 1st of July. So it's obviously going to differ between the periods. So if we're talking about now versus when we're talking after the actual full implementation, if you're no longer the agent, that record, and we're going to go through that specific retention, must be kept for 5 years after termination. Regardless of that, you cannot pass on personal information of data subjects should somebody just request that information. So I would suggest that the information be processed and passed on by the consenting party, which is going to be the data subject after the 1st of July, just to keep yourself safe in this regard. We actually had a discussion with a client yesterday, specifically regarding other service provider and how difficult it is actually to get information directly therefrom. And the reason for that is they just trying to protect themselves when it comes to the protection of personal information and the allocation of that information to a third party that might not necessarily have to have access.
So this question actually sounds quite similar to one which we get quite a lot.
Yes.
In terms of, can I share the tenant's credit check with the landlord? And the answer is ultimately the agreement, the lease agreement, is between tenant and landlord. So the estate agent can absolutely share the information with the landlord as they are the party that the tenant
Parties
is
to the
transacting with. So in
Of course.
terms of a copy of the credit check and supporting documentation for the application and the lease agreement, the landlord ultimately is the contracting party.
100%. It's
Yeah.
a two-party agreement in
Yeah.
terms of the lease. Good. Okay, so your record of directors, electronic and physical, must be kept for 7 years, and your minutes of directors meetings, also electronic and physical, 7 years. Michelle also talked a little bit about the financial records of TPN. This is obviously not just depending on your audit, it's all the financial records that you might have in terms of your company. Your annual financial statements, electronic and physical, once again, kept for 7 years. Accounting records as required by the Companies Act, once again, that piece of legislation comes into play, 7 years. Financial agreements, 7 years. Banking details, 7 years, and then your SARS submissions and other documents regarding your taxation must be kept for 5 years after the actual submission to SARS. So you can see all of these different pieces of data or information actually has different retention periods depending on what we're busy speaking about for your company. Insurance of the company, both of these, your insurance policies as well as your register of all immovable property owned by the company must be kept for 7 years as well. Then we get to the nitty-gritty, the HR as well as the client information on your system. Now, this is something very important. Remember, in the previous modules, it was the last one, I believe, we actually went through the HR module and we showed you exactly what type of information you are going to keep on your employees in the business. But this relates specifically to the retention periods of that information on your system. So, list of employees, whether they be electronic or physical, is 3 years. Personal information of employees, also 3 years, but after termination. Employee contracts of employment, once again, 3 years after termination. Pension funds and provident funds, 3 years. Salaries of employees, 3 years. Your leave records for 3 years. Your health and safety records of earning and other prescribed particulars of all employees, 4 years in terms of the Occupational Health and Safety Act. And then health and safety committees and incident reports, also 3 years in terms of that piece of legislation. Good. Your company policies and directives, both must be kept for 7 years, and this relates to your internal policies, procedures and directives relating to employees in the company, as well as your external policies, procedures and directives relating to clients and external parties. Must also be kept for 7 years. Your agreements or contracts, and these are the ones you're probably getting a touch on with relation to your specific business, whether you be an estate agency or if schools are joining us here today as well. Your standard agreements must be kept for 3 years after termination. Contracts concluded with customers. And this is the possibility of the mandate agreements, etc., must be kept for 5 years after termination. Your NDAs, non-disclosure agreements, electronic and physical, 3 years after the termination of that NDA. Letters of intent, memorandum of understanding, also electronic and physical, 3 years after termination. Third-party contracts such as JV agreements, etc., partnership agreements, all of those, electronic and physical, 3 years after termination. Office management contracts, also 3 years, and then supplier contracts, also 3 years, whether they be physical or electronic. Your regulatory processes, good, Michelle? Question?
Peter, there's a comment that keeps popping up in the slides, so I would like if you could just address it quickly. All the slides that Peter is sharing now, we're going to happily share with our delegates at the end of the session. So when you've completed the feedback forms, all those delegates who do complete the feedback forms, we will then share those slides.
Thank you, Michelle. And I'm sure we're going to put our contact details up once again. So if you don't get those, please contact us directly and we'll send them through to you as well. So licenses or authorities, electronic and physical, and it's indefinite. I probably should have given a different answer to that and said, no, it is part of your policy and procedure on the TPN POPI-Portal. So if you wanted, I'm joking. Okay, we'll send the slides to you. Don't worry about it. Published information, external newsletters and circulars, electronic and physical for 1 year. Internal newsletters and circulars, electronic and physical 1 year. And then information on the company published by third parties, also a 1 year period. Customer information, and now this is vitally important. You all have sight of, you all know about FIC. I think we've done a couple of FIC training sessions. They're even available on the TPN YouTube channel. Go and have a look at those. But FIC's vitally important for the retention of information as well. And what I just want to reiterate over here is POPI does not necessarily prescribe the time periods involved and how long the records must be kept. It relates directly to FIC. As you saw in subsection 16.2a, it specifically says if it is prescribed by a piece of legislation or the law. So customer details, electronic and physical, 5 years after termination of the contract, that information must be kept. Contact details of individuals within customers, also 5 years after termination. And then all communication with customers, whatever those might be, if they take the medium of either electronic or physical, must be kept for 3 years after termination as well. So dealing with this specifically, and this is where the fun starts to happen, and this is where the IT team actually got involved, is the destruction of paper records as well as the electronic data. Now, where a formal decision has been made by the company to destroy those records specifically, it must be done securely. And this is also wording taken directly from the policy and procedure. Paper records must either be shredded by the company or placed in confidential bins to be removed by a reputable third-party provider. Paper records must not be discarded in trash cans or destroyed by any other unsecured means. And I always make this joke, but attorneys always have that sort of file 13, the bottom file in your desk. That's not the place to discard papers, okay? That must go in the secured bins or it must be shredded by yourself. So like Michelle said, we've got this TPN policy and procedure that we follow with the third party involved. But to show you this in a little bit more of a practical way, let's have a look at the IT team.
Hi there, you're here to destroy the documents.
Yes, I'm here to destroy the documents.
Please follow me.
Okay, thank you.
It's a heavy one. Let's just check it's all empty.
Yes, empty.
Great. Just make sure the cupboard's locked. That's good.
Right here, send
Thank you, sir. This is at the bottom here.
top, your name, down signature.
Thank you very much, Justin, for that one. I hope you all enjoyed it. That's exactly how we follow the procedure at TPN when it comes to the destruction and shredding of our paper information. It's absolutely vital that you follow a very similar procedure when it actually comes to the destruction of that data, because as you all know, paper in bins is not going to work here. So we sign off on everything, but we use that third-party service provider to actually destroy that specific data for us, and we know that it's done in the correct specific method. Now, like I said, I'm not the IT person at TPN, and I was very flabbergasted when I learned of how you actually destroy physical hardware when it comes to data stored thereon. But there's two different destruction of electronic records when it comes to the policy and procedure that has been loaded onto the TPN POPI-Portal that you also need to consider. And this relates directly to the destruction of electronic data. So electronic means of communication, electronic information that is actually saved on your servers, on your computers, whatever it might be. They cannot just be deleted. That is not destruction. And when we talked about this policy, there were two things that sort of came about and we just started to discuss. Obel specifically told me it's not necessarily up to 10 times, it can be up to 7, but overwriting is an effective method of destroying electronic records, and it basically involves the use of software that overwrites the records multiple times, so that that record has been de-identified or deleted or destructed as a result of that process, and that can happen up to 10 specific times. And then physically destroying storage media. And that includes certain ways of destroying storage media. I'm sure you're going to find this video very, very exciting when it comes to the destruction of the records itself. But before I get too involved in this, let's move right over to Bruce to show you exactly how that's done at TPN.
Hi, I'm Bruce from TPN IT. I need to decommission this computer. Now, will formatting the hard drive erase the data? No, it won't. Will physical damage to the hard drive erase the data? No, it won't. Physical damage to the hard drive might not remove the data. The spindles might be in perfect condition. For peace of mind, the best way to destroy your data is to damage the spindle. That is our data destruction policy at TPN.
Thank you very much for that, Bruce. Looking very good in the TPN blue. So that includes the physical destruction of the records. It actually means that you're physically destroying the hardware, which is absolutely vital when overwriting processes or other processes of actually deleting that data cannot be, let's call it, assented to and cannot actually happen in the business. Physical destruction is something that's vitally important. Michelle actually likes to share the story, but Chris sometimes goes and uses a hammer on certain parts of the hardware as well as a drill. So very important to note, physical destruction is not just the deletion of records. Michelle, that brings us to the conclusion of our formal training today. I'm sure we've got a lot of questions. Can we move over to that, please?
Yeah, please, Peter. Noelle is asking, can you burn after shredding? I guess you can, but is it necessary?
I'm guessing if you don't have wood for your braai, paper's not necessarily going to work. So yes, obviously you can go and do so if you'd like. Then it's definitely going to be destroyed, yes.
I think the bottom line is to find a solution with a reputable company
Yes.
where the data is destroyed in a manner that doesn't need to be destroyed twice. So shredding and then burning it seems like overkill, even if I may say so. Linda Kelly is asking, so shredding CDs, acceptable or not?
So shredding CDs most certainly, if not.
No, absolutely. No, I'm
good.
nodding,
Okay.
absolutely.
Well, sorry, I saw something completely different there. So yes, definitely you are allowed to shred your CDs as long as it's physically destroying the data on the CD itself and it cannot be reproduced in any other method or remanufactured, then most certainly shredding CDs would be absolutely perfect, yeah.
Okay, so Marlies from NationLink, I assume it's Marlies, but from NationLink Plateaukloof, the question is, we have copies of all agreements dating back to the 1980s in digital format and regularly get requests for info from clients involved for divorces, etc. Must we destroy everything older than 5 years?
That's a very interesting question. I mean, if the people are still requesting those records 5 years or after termination, I can only speak to what the legislation specifically says on this. So in terms of the FIC legislation, as well as what I've shown you on the screen, specifically the tables that we've drawn up, that information should actually only be kept for 5 years after termination. So inherently, I believe that those records must be deleted, destroyed, or de-identified at least, because it's very possible, or let's not call it possible, but you do run the risk of a third party accessing that information, and technically, in terms of the legislation, you should not be having those electronic or even physical records.
So ultimately, it's up to the security that's involved in terms of protecting that,
100%, sure.
in terms of protecting that data. Dean has asked, our clients are creative today, Peter. Dean has asked, what about dumping the records in black paint?
That's an interesting way of destroying records. I'm going to give you an answer that just says as long as it cannot be reproduced in the physical format and that information cannot be, let's call it, captured or seen by another party, I'm sure that the black paint option could work, yes. I like the creative questions today.
Love the creative questions today. I mean, I personally just like it when our clear data arrives in their truck and deals with it.
Whatever floats your boat. If that's fun on a Friday afternoon, who's to say it's wrong?
Sheila has asked, is the 5 years calculated from the start of the contracting process or the end of the contracting process? I like that question.
Great question. Thank you so much. The legislation says after termination. So once the business relationship or the transaction has ended, 5 years from that period going forward. So it's not the start of the transaction, it's the termination or the end of the actual transaction between the parties.
Which makes a lot of sense. If you have a tenant in a property that's there for longer than a 5 year period, you want to retain all the information, all the records associated with that relationship over a period of time. Goss Properties are asking, with the new Property Practitioners Act, aren't we supposed to keep our records for 10 years?
Yes, it is possible that in terms of the Act, it is going to override certain sections of other pieces of legislation when it comes to the retention and destruction. I think that's one of the reasons why they don't actually physically in the Act, in terms of POPI, specifically prescribe how long certain pieces of information must be kept. So as soon as there's a different piece of legislation that relates to the retention and destruction of that specific record, whether that be the Property Practitioners Act, whether it might even relate to the Rental Housing Amendment Act. At the end of the day, that piece of legislation is going to override that. So yes, then that information would need to be kept for a longer period. Correct.
And a question that hasn't come up, but I always like to look at the National Credit Act in terms of the retention of data on the Credit Bureau. And we have a section that highlights the different types of information. And in that act, there's different time periods associated with each of the 11 different data categories. Maybe you could share some of those with us. Peter.
I actually asked you one this morning because I wasn't 100% certain. But say, for example, you perform a credit check on somebody, that information that is displayed on their actual credit profile is only for 12 months. It's
we like to call that footprinting.
Footprinting, lovely. Whereas payment profile information, so that's your line item records, exactly how the person is paid each and every single month, we can only keep as a credit bureau for 5 years. Judgment information is going to be captured for 5 years as well. And then blacklistings, as we always say, is only kept for 12 months. And there's processes involved in this as well. But there's definite restriction periods that we have to deal with in terms of credit information, straight from the National Credit Act. Yes.
Absolutely. And in fact, those payment profile data, albeit that we can display it for 5 years, some of the bureaus actually choose only to display for 2 years or 3 years. And in TPN's case, from a rental payment profile or a school payment profile perspective, we do show the full 5 year history.
I didn't want to say this, but I almost always submitting to the bureau, so remember that.
And Peter, maybe you could just also look to prescription. So we say that judgments only last for a period of 5 years, but in actual fact, if you take judgment against someone, you have a much longer period to go and collect on it.
You do, Michelle. You've got a period of 30 years thereafter to try and collect the money therefrom. But remember, the prescription period relates only to the period when the money is claimed. When the money is due versus when the money is actually claimed. So you need to actually institute action, or you need to get a judgment prior to that prescription date, and then that judgment, even though it's only reflected on the credit bureau for 5 years, will be legally enforceable for the next 30 thereafter.
Anna Marie is asking, can I blacklist a tenant after 12 months? Now, that question on its own you can deal with. Can I blacklist my tenant after 12 months? But the question goes a little bit further and says, can I blacklist my tenant after 12 months again?
Oh, okay. Can we deal with the first section and then the second section?
Please.
Let's do that. Okay. So yes, you can definitely blacklist your tenant after 12 months of non-payment, or if the contract has run, or if the contract has ended and the time period hasn't prescribed yet. Remember, we're talking about that 3 year period in terms of the Prescription Act, yes. So you would be able to blacklist that tenant. Regardless of me saying that, you only have a single bite at the apple. You will never be able to blacklist again for the same debt that was due and owing from that year period or the 12-month period that we're talking about. So that's vitally important. Only blacklist once for that specific amount that was outstanding. One bite at the apple.
And in fact, that's in legislation.
Yes.
So there are very clear guidelines as to what we may do. And TPN tries to facilitate those guidelines. When you go on and load your default listing, there's certain things that need to be in place. And if we see that you haven't, for example, your account's not 3 months in arrears, we're just not going to process that default listing.
100% correct.
When we see you've loaded it once before, we're not going to let you load it a second time.
We're not going to let you. Once again, if you need more information on that, we actually get blacklisting queries almost every day from clients.
Like I was going to say every minute.
Every minute. But you're more than welcome to contact the TPN Legal Help Desk line so that either Greg, myself, or Jade can assist you with that as well.
Kosi's got a nice question. Would it be a good idea to send clients communication about the retention periods of their data with us post the termination? I mean, that just seems like a lot of work.
It does seem like a lot of work. And I'm gauging it doesn't happen very often that clients request the information after a certain period. I mean, we do sometimes get consent disputes when it comes to a person performing a credit check on another person, and we ask for that information when it comes to the consent. But you could, if you'd like.
I would absolutely, yeah. I would absolutely. It's covered in your agreements with TPN. So POPI retention is covered in your lease pack agreements. Gary has asked a question that you were prepping for earlier. So Gary has asked, how long can we keep unsuccessful applications for either rental or for recruitment purposes?
Okay. So this came up quite a lot. Remember what I just talked about in the beginning when I said that the footprinting on the actual credit profile. So how long the actual footprint stays on the person's credit profile for when you've performed that credit check is only 12 months. So a person will not be able to see that thereafter that process has actually been completed. For anything like that, and this relates also, let's not just talk about the application documents, because usually through an application, you're collecting some other information as well. So you're collecting credit information, you're perhaps collecting pay slips, you're actually collecting financial information of the prospective tenant itself. Now, as a result of the transaction not actually occurring and then being no termination, it would most probably fall into one of two categories. A year after that actual has occurred, so after the credit check has been performed, nobody's anyway going to see that information thereafter, so there's not going to be anything on the credit profile itself that says that the credit check has been performed. With regards to perhaps the tenant entering into the transaction, it sort of relates to a different time period, and then we're talking about FIC legislation, so even if the tenant has just been there for a month or whatever it might be, it's going to be 5 years after the termination of that specific period.
So Risa has asked the question slightly differently. So the application that Gary asked is an unsuccessful application, how long do I hold on to it? And Risa's asked, for a successful application, how long do I hold on to it?
Okay, so for a successful application, once again, the transaction has actually started. So there is that business relationship between the parties. So it will be 5 years after termination of the business transaction, the relationship actually between the parties, which in this instance would be the end of the lease agreement or the end of the mandate period.
Fantastic. And just to remind everyone that we have I've placed the feedback form link on the chat. So click on that link, go into the feedback and give us your critical judgment and assessment of today's session and anything that you'd like us to address in the future.
Please.
So we do like your guidance in terms of creating the content for these different sessions. Peter, that seems to be the end of the questions. Is there anything that you'd like to address as a closing comment for our clients?
I think at the end of the day, and me and Michelle actually had this discussion yesterday evening when we were talking about a different client in the POPI-Portal specifically. But at the end of the day, POPI compliance is so incredibly important when it comes to this. It's obviously important getting the right documentation in place. It's obviously important doing your personal information impact assessment. But the actual practical methodology of destruction or retention of records and understanding that entire process is very, very, very important. It's going to be, let's call it, pivotal in this entire POPI process. So remember, if you've got any questions regarding this, please feel free to contact us on the help desk lines, the legal lines. We will put those contact details up in the chat as well. But for now, please remember, subscribe to the TPN YouTube channel, hit the notification bell so that you get notified of any upcoming trainings. And can't wait to see you for, can you believe it, Module 5 of 10. Have a fantastic day further, everybody. Enjoy.